volunteer departure and adjustment of status, or volunteer departure and seeking readmission. When a person has been granted volunteer departure and they fail to leave within the time frame allocated by the immigration judge, then this person will be banned from adjusting status. They will be barred from adjusting status for 10 years, okay? And when the time comes for adjustment of status, this person has to go back to court. He opened the case, tried to terminate removal and adjust status with USCIS, or he opened the case and tried to adjust in court. That's just how it's going to play out. And the burden of proof is on you if you claim that you left, because there's a person who claimed that they left the country. However, they left after maybe 90 days. They did not live within that time frame, and then they claim that they stay outside of the country for 3 years. Therefore, the 10 years bar does not apply to them. I was like, no. It still applies to you, because the burden of proof is on you to show to USCIS that you meet the eligibility requirement for adjustment of status. Because if you claim that you left the country, then you have to show us when exactly you left. Because you have to show USCIS, not us, really, because I'm on your side, right? So you have to show USCIS when exactly you left. So if you fail to show that, then USCIS is going to assume that you did not leave within the time allocated by the government or by the immigration court, and therefore you are barred from adjusting status for 10 years. And let's say the 10 years now has passed, so you still have to go back to court, reopen your case, and adjust status, because USCIS does not have jurisdiction over your case. And then the second part is about people who left voluntarily within the time frame, and now they're seeking admission or readmission to the United States. Those people are not barred generally from re-entering the United States. However, they can be found, okay, inadmissible on other grounds. For example, unlawful presence count. But those grounds, we know that it can be waived if you have a qualifying relative, right, parent or spouse, to waive that unlawful presence count. So it's less complicated than someone who failed to deport. And sometimes too, the people who actually leave, sometimes they get lucky, and the consulate can overlook that part of unlawful presence, and then they can just come back. But you just have to know that you might leave voluntarily. It doesn't mean that some other grounds of inadmissibility are not going to be applied to you. You know, the only bar you are not going to be under is the bar of removal order, because the order of removal is attached to certain bars. For example, 10 years, 5 years, 20 years, or permanent bars. Those are the bars that are not related to your case because you left voluntarily. However, you can be found inadmissible on other grounds. So you have to know the difference. So if you need a consultation with me, you can schedule it by using the consultation link in the description box below. If you need guidance, we always encourage people to seek advice before, not after. You know, seeking advice before, it's better than seeking advice after the fact. In the next video, I'm going to talk about when the person seeks advice after the fact, it's always trouble. Thank you very much. Until next time, bye-bye.